time called as the bus law, school bus case. Now, when the US Supreme Court talked about mixed school, there was a lot of opposition, not only from government but also from the parents. A white parent said, "My child going to a black school, he may be monk. The black children are all very rowdy, very rude behavior." A similar feeling was expressed by mother of black children. "My son cannot go to white school, he will be ill-treated." But then there was also a lot of opposition in the public. The US president, typically representing the mood of the people, said, "We cannot implement this order." The Brown versus Board of Education, you can have access to Google, you can read the judgment. How the court can see the future of the country. The moment the US president said that we cannot implement the order, the Chief Justice of the US Supreme Court made a declaration that if the US President do not send or implement our order, we will call the US Marines to implement the order. This is a threat they gave, and then in a short time, this became a reality. And today you do not have any color school in America. In the last 60 years, there was a leap forward. The leap forward you can see with a small index. Barack Obama, he was a Howard scholar. He was made the president not one time, but two times he became president. He was a black. It could be it could never be thought of. Such things can happen. But in America, wedded to the policy of non-racist approach. The very America was constituted against the slavery from the Britain. But within that there was a slavery, and that slavery took time to abolish. And now this judgment in 1966 became a landmark, and the result you can see in your room. You come back to our court, take the question of education, how our Supreme Court reacted at different times. Now, when the Constitution was framed, the Constitution framers did not think that education should have a fundamental right. They put it in the directive principle, which cannot be enforced in court. But it should be duty of the Parliament to make laws to bring the directive principle. Though Article 45 provided for compulsory free education for children from the age of 6 to 14, it was never a reality. It never became a reality. And therefore, people attempted to say, not rely upon 45, and attempts were made to bring education as a fundamental. The court did play a very significant role. The first case came from Karnataka, where self-financing institutions were running medical colleges. A girl by name Mohini Jain, she was not able to pay the capitation fee to want to buy education. She said, "I have no money to buy education." So she went to the court. The court took her case very sympathetically. Justice Kuldeep Singh wrote a very brilliant judgment. He said, "You cannot charge a fee for coming to the education institution, and charging capitation fee is never thought of. But then there is no fundamental right to education." So the judge made a small departure. He said, "I will not look into Article 45, which talks about directive principle. I will read a fundamental right." How to read a fundamental right? He looked into Article 21, which guarantees liberty. Then he started by saying, liberty does not mean animal existence. If you do not want to live like an animal, you should have dignity. How does one get dignity? It is by education. Therefore, he said, what the Constitution framers did not mean, they never meant, even their dreams, they never thought. But then, by a court process, education became a fundamental right, and Mohini Jain case, Supreme Court said that right to education is a fundamental right, and we can read Article 21, some kind of a judicial engineering. You read something positively, at the same time that was not originally intended for. Because to provide education, you need money, you need finance, and no government was willing to do this as an exercise. And the judges did as a first step. But Mohini Jain did not last long. There was another set of cases came. every medical college started charging capitation fee, and you either go to the government college or you go to private college paying hell of a lot of fees. And then when this matter came to the Supreme Court subsequently in 1993, Supreme Court Justice Jeevan Reddy, he had enough Jeevan to decide this matter. He said, we cannot allow education to be made as merchandise, to be sold. Therefore, we will evolve a scheme. On the one hand, private entrepreneurs are allowed, they must have money to run the institution. On the other hand, they cannot have a capitation fee because that would amount to profiting on education. Therefore, he made a via media, he made a scheme. What is the scheme was that you admit 100 students, 50 students will have a free seat and 50 students will have a payment seat. That is, a payment seat student will be supporting the education of a free seat student. This was a formula used by the Supreme Court called Unikrishnan case. But while deciding Unikrishnan case, one point came whether Mohini Jain talks about free education. Can a medical education can be free if that is true? Justice Jeevan Reddy had his own problem, therefore he made a via media. He said, if you look into Article 45, it talks about age from 6 to 14. It does not go beyond. That means only school education. If the Constitution itself talks about school education, how can bring it to higher education? This is a second step. Therefore, he made a via media that no doubt up to school education you can have a free education, but higher education one has to pay. In that payment, the private operators can charge a higher fee, and the person who pay payment fee, he will be subsidizing the fee of the private school. This is a model, the model which is brought in a judgment. Since we are talking about judicial activism, we'll have to talk about this. When this judgment came, number of colleges started admitting 50% government quota, 50% management quota, but still they could not eradicate capitation fee. Many of the state governments brought a new law prohibiting capitation fee, and how much it worked is a different issue. Later the Supreme Court took over the task of fixing the fee. But what is important was the pressure of the private management was so much. The Unikrishnan case was reviewed. Unikrishnan case was read by 7 judges. It was reviewed by 11 judges, a bench headed by Justice Kripal. The argument was, I have a right to carry on a trade, I have a right to carry on occupation, I have a right to have a calling, in which case how do you now restrict my right? Therefore, there is a fundamental right to run free, not private education institution. Therefore, the Supreme Court for the first time said, a private operator is allowed, which is subject to regulation. What kind of regulation? The regulation could be the standards of education, the syllabus, the examination, the infrastructure, all that. What about the fees? They said the management will fix their own fees and not by court orders. So the first time Unikrishnan was erased, the judges in their own, I would only say, uncharitable way of saying, they called Justice Chinnappa judgment as unconstitutional. Nobody ever calls a judgment as unconstitutional. You can say it's a wrong principle of law. They overruled Unikrishnan and finally laid down a law. 3 things they said: the right to carry on trade includes right to carry on education institution. And then how much government can regulate? The regulation is only minimum. In a government-run institution, you can have a greater regulation. But a purely a self-financing institution, it will have its own rules. You can have a minimal interference. Therefore, for the first time, in one of the judge who wrote a supporting judgment said, in these days of globalization and the universalized education, education can't be stopped. Therefore, we should be happy that we are able to provide such kind of education institution. Therefore, the Mohini Jain had its own natural death. So the activism works in different ways also. It doesn't mean it works only in the way forward. It can also work in the backward method. So when the final judgment in the TMA Boys case, the court said that the entrepreneurs can run, apart from several other trade activities, they can also have education activities. This is one direction. Now what about school education? Everybody says Constitution provide for a compulsory, universal free education. Why not we have free education? So in 1999, Parliament amended the Constitution and brought Article 21A, where they said between the age of 4 and 14, there will be universal free compulsory education. Now this is correct. Now it has become a fundamental right, as envisioned by the constitutional framers, though they did not make it as an enforceable right. Now in 1999, it became an enforceable right. What follows? Does it mean school education now become free? There are even Montessori schools which are running 1 lakh rupee. LKG section, kindergarten section, 1 lakh rupee. Very, very unheard of. But then the law talks about universal free compulsory education. Now this question, how to enforce this order? The word used in Article 21A, the state may provide for. The state shall provide for. The word provide for is very important because an activist, how does he look at this? A non-activist, how does he look at this? This is an issue. Typically, after several years of drafting exercise, in 2012, the Parliament passed, 2009, Parliament passed a law for a right to free compulsory education act to give effect to Article 21. As expected, all these educational merchants went to the Supreme Court. The top was the Rajasthan Private School Association. They filed a case and several thousand cases came. It was heard by Justice Kapadia. He had very good intention. But then he had a problem before him, the structural problem. There are government schools, there are local body schools, there are private aided schools, there are also unaided schools. Now you have 4 categories. Like say if you go to mall, you have every choice of anything you can buy. Like that in the educational field, you have different kind of education system. Now this law says you must provide free. Does it mean all the unaided school will be taken over by the government? What about the finance? So the judge looked into the issue, not from the standpoint it should have been looked into. He looked at a different side. How do you interpret Article 21A? The argument advanced by social activists was it should be the duty of the state to provide. Even America called as a private enterprise. So far as the school education is concerned, entirely the state funding. There is no private. There are very minority, not even 2% of the schools in America are private schools. All of them are all neighborhood schools. Now we also have a neighborhood school act where a parent wants, if he does not send the children, he will be punished under the act. He has to send the child to the school. There are several schools in that area. There are municipal schools, there are aided schools, there are also unaided schools. Now there is a clamor, it's an unaided school which has got very great attraction. So as a neighborhood school, I go to the school, I want to put my children. They say no, we won't. With this judgment, which was argued hotly, Justice Kapadia wrote an order. Provide means the government need not provide directly, it can also provide indirectly. Provide through some other agency. Now this is where you see the American judgment, Brown versus Board of Education. You see the Rajasthan case, it's an opposite. Now the learned judge said that shall provide means it must provide. At the same time, it need not run the schools. The word provide means provision. Beyond that, he does not know. So he completely whitewashed the state role to provide the education at the school level. So the very purpose of Article 21A was defeated. He also went to the other extent by saying it will not apply to minority schools. Number of minority schools you see in even Trichy. If you take the number of children studying in school, 50% will be studying only in the minority schools. The other schools are very minimum, the state schools are very less. But then the judgment put a two-rider. One, the state need not run all the education. And secondly, minorities did not apply. Completely the entire thing is worked out. The third thing was more important, that it did not define what is a neighborhood school. Do the parent has got a choice to go to particular school. On the other hand, the Act said all unaided private schools should have 25% of the seats meant for underprivileged children. Therefore, when the private enterprise comes in, they will have 25% of the seat reserved for them. It's not free seat. The government will have to subsidize that amount to the schools. Which means what the government did not do directly, it has to do indirectly, subsidizing an unaided private school through this act. That was never intended. Now they are also subsidizing now. There are 25% seats are available. Shall provide means providing through agency. Now that has been provided. Now what follows? As soon as the act was upheld in 2012, the one principal in Madras school, she wrote a letter to all parents. Dear parents, there is a news for you. Henceforth, your child will be sitting with the children of your own maid, servant maid. This was the warning given by a school manager. So that is the attitude that we have, that we do not want underprivileged children come to some fancy schools, some elite schools, some schools which are considered to be the top in the ranch. This is something which is never thought of, but then that is what is happening today. Today, a poor children studies in a municipal school, a rich children goes to a good school, and then whatever the act remains in paper. As a judge, I wrote an order. In 2009, I wrote a judgment. In 2011, I wrote a judgment that this act do not define what is neighborhood school. If there are 4 schools in an area, the parent does not have a choice. It's the management which will decide whether to take you or not. The management may take you or may not take you. They may not take a son of a servant maid. They ask the parents' status, and then they will not take you. So now the elitism continues. In fact, I studied in an ordinary school. In fact, I was born in Tirchi. My father thought there were not many schools, so I went to Madras. Then we went to some ordinary aided school, and that's a very marginal pay you are getting. There were some scholarships available in those days. And my school fee was 6 rupees. And if you come under merit from means test, it will be 3 rupees. But then we paid that amount. But what is important is, after I became a judge, my school called me for an alumni meeting. They said the proud alumni will become a judge. So I was only judge from that school to become a judge. That's not a great compliment. I was asked to speak. I said, today in India, we have some schools which produces prime ministers. Today in India, this school produces bureaucrats. There are some schools like our school produces good citizens. Without a citizen, you can't run a democracy.